So a bit of a disclaimer up front, I'm going to be talking more about the Notifiable Data Breach scheme than how to win friends. So if that's what you came for, I apologise. There was an asterisk there, so my bases are covered. Really quick thank you to the sponsors, without which we wouldn't be here. So I'll start off with a bit of a spiel about me. So obviously I am Cairo, just like the city, in case you were wondering. I'm an information security consultant at Asterisk. I'm also the Perth chapter lead for the Australian Women in Security Network. So any of the girls out there, if you're interested in cybersecurity or working in cybersecurity, definitely hit me up. We'd love to have you coming along to our meetups. And just a bit of a disclaimer, I'm totally not a lawyer. So if you're going to take this as legal advice, I take no responsibility for anything that may go horribly, horribly wrong. Did my mic go off? Oh, it's back. Cool. All right, I also spend way too much time on Twitter, so follow me. I want more followers. That would be great. So the main reason we are here today is to talk about the Privacy Amendment Notifiable Data Breaches Act of 2017. So this became law last February, about 18 months ago, and the scheme itself officially kicked in on February 22nd of this year. This act basically established breach notification obligations for entities that are subject to the Privacy Act. So a bit of a background on the Privacy Act. It's Australian federal legislation passed in 1988, same age as me. It's Australia's main privacy and data protection law. And it's what we describe as principles-based legislation. So it's not a prescriptive list of technical do's and don'ts that companies have to adhere to. It basically kind of sets out the high-level aspirations that we have in terms of privacy and data protection. It's been updated 3 times in the past 30 years, which I think is pretty interesting given how much technology and privacy has changed in that 30 years, so that's something to keep in mind. The main section of the Privacy Act is the Australian Privacy Principles. So this sets out the obligations of organisations when it comes to protecting personal information. It also sets out a lot of rights that individuals have. So this is the right to request data is deleted, the right to have inaccurate data updated, those kinds of things. One of the main things that the Privacy Act defines is what actually constitutes personal information. Unhelpfully, it defines it fairly vaguely as information that makes it known an individual person exists. So we all know exactly what that means, right? We're all on the same page. This definition actually it changes regularly based on how the courts actually interpret it. So I don't know how many of you followed the case of Ben Grubb a couple of years ago. He's a tech journalist and he put in a request to Telstra to get copies of all of his metadata. When he initially made this request, the courts ruled that he could have access to all of his IP logs because they were logs pertaining to his usage of his service and therefore it was personal information. Upon appeal from Telstra, that interpretation was overruled and they decided that the IP logs actually pertained to information about a service rather than a person, and therefore it wasn't considered personal information. So there is that back and forth in terms of what actually falls under this definition. So it can be a little bit vague, so that's something to keep in mind. So we'll go over a bit about the OAIC. So this is the Office of the Australian Information Commission, and they're the main enforcement body for the Privacy Act. They're empowered to investigate violations of privacy. There's 2 ways they can do that. They accept complaints from individuals when they feel that an organisation has violated their privacy, or they can initiate an investigation of their own accord. So if something hits the news or they receive industry news about something, they can decide if they're empowered to investigate. One of the main issues with the OAIC is they are chronically underfunded. The government doesn't really give them a lot of money. If you go on their website at the moment and submit a general request, I think there's about a 4-week wait time to actually get a response. And that's just a general email request, it's not even a complaint. So that's mildly concerning. There is actually supposed to be an information commissioner and a privacy commissioner, and they're supposed to be two separate roles. They've been fulfilled by the same person for the last couple of years because there's not enough funding to have two. So that really makes us feel like our privacy is being protected, right? The OAIC has the power to take legal action against organisations that are found to be in violation of the Privacy Act. They can issue fines of up to $3 million in the case of the I can talk really loudly. Oh, cool. We're back. Cool. So in the cases of the Notifiable Data Breach scheme, I think the maximum fine they can issue is about $2.4 million. They can also do a really, really fun thing known as Enforceable Undertakings. And I can guarantee you that any organisation that's investigated by the OAIC, their #1 goal is to not get one of these. It's essentially a legally enforceable agreement that organisation will do everything that the OAIC tells them to do to remediate any issues. I believe Optus at one point entered into an enforceable undertaking, and it was about 5 years until they were actually done with everything they were told to do. So your opinion on that will probably differ based on if you work for that organisation or not, but generally speaking, it's a lot of work. So on to the actual Notifiable Data Breach scheme. So unsurprisingly, it basically does what it says on the box. It sets out the notification requirements for entities that have experienced a breach. So prior to this coming into law, notification was entirely voluntary, and unsurprisingly, not a lot of organisations decided to tell people when they had been breached. Obviously, there's a financial impact, reputational impact, and they don't really want to do that. So as part of this breach, the organisation has to do an assessment of what the impact of that breach would be to determine if it's actually eligible for notification. And once that's been determined, notification has to be provided to both the OAIC and the individuals that are affected by the breach. So there's two outcomes of this. The individuals are actually notified that their data's been breached, and the OAIC actually gets to gather a whole bunch of statistics on data breaches, which is actually pretty cool. The first full quarter results have actually just been released, which you can read on the OAIC website. It's really cool reading. That was not sarcastic, it sounded it, but it wasn't. So the first question is, what entities are actually subject to this scheme? So the scheme applies to all organisations currently subject to the Privacy Act, and this includes businesses, government agencies, and not-for-profit groups that collect personal information. That's the broad application. There's a whole bunch of exceptions to this. So currently the Privacy Act doesn't apply to businesses with an annual turnover of less than $3 million a year. So small to medium enterprise don't need to comply with it. There is an exception to the exception, just to make it really easy to follow. If your organisation handles tax file numbers or health and medical information, then you do need to comply with the Notifiable Data Breach scheme. And I can guarantee you there's a whole bunch of organisations out there who haven't realised this yet and are probably going to get caught out at some point. One of the ones that concerns me the most is it doesn't apply to state or territory agencies or organisations. So the Privacy Act is federal legislation, and it doesn't apply to actual state agencies because states are empowered to make their own privacy legislation. In WA, we don't have any at this point. And if you think about the services that the WA government actually provides, it's a little bit concerning. So that would cover public hospitals, most primary and secondary schools, that kind of stuff. A little bit concerning. And there's also an exception for registered political parties, so they can do whatever they want with your data. And employee records also aren't covered under the Privacy Act. Those are covered by workplace relations legislation. The exception to that exception, I'm sensing a theme here, is that if you as an organisation do outsource the management of your employee records, then it is subject to the Notifiable Data Breaches scheme, which is why there was the big PageUp breach recently. Had all of those organisations been handling their own data, they wouldn't have actually had to tell anyone. So take from that what you will. So in this case, you only need to notify for data breaches that are deemed to be eligible. So first up, we need to define what a breach actually is. So the OAIC defines a data breach as unauthorized access or disclosure of data, as well as the loss of data where it could then lead to unauthorized access. So if you accidentally wipe all of your data, that's fine. If you leave all of your data on a hard drive on a bus and someone may get hold of it, not quite so fine. So we're also only talking about breaches that involve personal information. Corporate data is not covered, so if you work for a company and your corporate data gets hacked, we don't care, really, let's be honest, that's your own problem. And the final requirement is that the breach has to be likely to result in serious harm to the individual whose data has been breached. So this is a pretty big question. What actually constitutes serious harm? There's no legal definition of what exactly that means. The OAIC has issued this guidance, which specifically calls out physical, psychological, emotional, economic, and financial harm, as well as harm to your reputation. So there's a whole list of things that this could involve, but the thing that kind of gets me is the requirement for a reasonable person in the entity's position would identify this as a possible outcome of the data breach. So essentially what this situation leads to is you have an organisation doing an impact assessment of a breach on behalf of the people who are actually affected. And that organisation, generally speaking, is going to have a vested interest in determining that, hey, we don't actually need to do notification. So there's that conflict of interest there, which makes me mildly uncomfortable. The other thing that is kind of an issue is that as individuals, I'm going to use a little bit of security speak here and I apologise. We all have slightly different threat models in our lives, so what's going to cause serious harm to me is not necessarily the same for other people. Everyone has different things that are going to harm them, and when it comes to an organisation determining the likelihood of serious harm, it's leaving out a lot of outliers, which are generally the people who are most vulnerable to experience harm. So in those cases, we're talking about people who've been victims of domestic violence, people with sensitive medical histories with stuff like they might be HIV positive, they might be sex workers, they might be homosexual, and that information getting out has a much higher likelihood of causing harm to those individuals than to people like me who aren't really controversial and are really only like allergic to bees. So those are the outliers that are going to be missed in this impact assessment, and those are the people who are most likely to be harmed. So I kind of personally object to anything privacy related that doesn't take into account the most vulnerable people. And that's something we're seeing a lot with the My Health Record debate that's going on at the moment as well, which I'm not even going to touch because I don't have enough time. So in terms of deciding that breaches are ineligible for notification, anything where you're like, there's not going to be serious harm. So it's either the serious harm is unlikely or the likely level of harm is not serious. And thirdly, if you undertake incident response activities in the case of a breach and you've managed to reduce the likelihood of the serious harm by doing that, then the breach is no longer notifiable. So for example, let's say you're trying to send someone's medical records off to another GP and you're going to do it by email because that's what we all do, and you send that to the wrong person. If you successfully manage to recall that email and it hasn't been accessed, no one's actually read it, in that case you've managed to prevent the serious harm and therefore it's no longer notifiable. One of the other exceptions is if notification would interfere with law enforcement activity. So let's say you work for an internet service provider, you're intercepting phone calls on behalf of law enforcement because you've got a warrant, hopefully. If that data was breached, in that case, if you actually notified that individual, you would be compromising that investigation. So you still have to notify the OAIC, but you don't have to actually tell the person. And that determination has to be made by the CEO of the organisation. There's also a blanket exception for secrecy provisions, and this is basically all the ASIO secret squirrel stuff. And finally, you can apply to the OAIC to get an exception. I don't think this is ever really going to be used, but I'd be interested to see who tries it and what the outcome is. So whether or not that'll ever be publicised is a whole other thing. So in terms of the notification that has to be sent out, there are some very specific requirements. So notifications to individuals have to include, obviously, the name of the organisation and how they can contact you. It has to have a description of the breach, can be fairly brief. You have to include the kinds of information that were breached. So is it just contact information? Is it credit card information? Is it medical stuff? You have to actually disclose that. And then you also have to include recommendations of next steps that those individuals can take to protect themselves from serious harm. So for most situations, this is going to be something like changing passwords, maybe entering into credit monitoring, cancelling credit cards, all that kind of stuff. So you do need to provide that advice. I'm interested to see what kind of liability this introduces for people if they follow that advice and something goes wrong. But that's something we'll see come out as the scheme gets more mature. If it's not actually possible to notify individuals directly, so if you don't have up-to-date contact information or something like that, you can publish a statement covering the breach with all of the information that would have been in a direct notification. And you also have to take reasonable proactive steps to actually publicise that. So you can't just hide a link in the corner of your website and hope that no one sees it. How far the OAIC will take that, I guess we'll see. In terms of notifying the OAIC themselves, they have unsurprisingly made this quite easy for organisations to do. There is a handy-dandy website, which I've put up there, but you can just Google it as well, which basically contains all the information that organisations need to give them as part of the notification. So that's a pretty smooth process. So I guess the big question is, what do you actually do if you work for an organisation and you need to comply with this? And I'm hoping people have already done this. But just in case, it's a bit of a refresher, I'll put my security consultant hat on. And number one, you need to know your stuff. You need to know what information you actually are storing, where you're storing it, what you actually do to protect it, and if you would actually know if there was a breach. If you've got no detective controls in place, you're going to have no idea. And not knowing that you had a breach isn't really a way to get out of having to notify people. Another thing I'd mention is you should definitely be considering what information you're collecting and why. If you don't need to collect information, you probably shouldn't, because then you don't have to protect it. You should also have incident response plans in place. So once you detect a breach, hopefully, you should know how to respond. You should have an assessment process in place so that you can actually assess that impact and show you're working should the OAIC come knocking and actually ask what you've done. And finally, have a communication plan in place so you know what you're going to say and how you're going to say it if you do need to do that. So that's pretty much all I had. I realised I got through the entire thing without a meme, so I've chucked it at the end. I know, right? It was close. So yeah, if anyone does have any questions or wants to chat, I'll be around all day, so just hit me up. Cool. Thank you.